This episode of Off the Cuff is brought to you by Weaver Simmons, and we're very pleased to bring it to you. I hope you enjoy.
Welcome back to Off the Cuff. My name is Darren Chohan, and I'll be your host today. For those watching the YouTube video, you'll see that I'm in a different location. I'm actually sitting at my computer at home recording this as I want to try something different for an episode or a series of episodes for the viewers and listeners, because I've been noticing a lot more that in the practice of family law, specifically, the self-represented litigants have been on the rise. And this is just the nature of, I think, the court system, the cost of accessing justice, and quite frankly, just an economy that's not doing so well, and the need for lawyers is rising, the demand is rising, the cost is rising, but quite frankly, there aren't enough lawyers that are taking, for example, legal aid certificates, and or, it's becoming cost prohibitive for a lot of people to try to solve their family law issues in court. And so we have actually noticed that more and more people, you look at a docket today and you see about 3/4 of the docket that is unrepresented. And that just tells you the state of our justice system and as a whole. And it's really cause for concern, because lawyers, in my view, of course I'm biased, help the situation where a lot of people think that lawyers make the situation more difficult. And so what my goal here is in this episode and series of episodes that you'll see is a way to provide self-represented individuals with information about how to fill out the forms, because there's nothing more frustrating than being a lawyer and looking at self-represented litigants' forms, which are often handwritten, they're deficient, and they don't have the information that we need to help assess the claim and advise our clients properly. And so it's in everyone's best interest that these forms are at least filled out correctly. And so that's my goal here today, is to assist people, at least if I can help somebody fill out their form properly, I've done my job today. And of course, nothing I construe on this episode and series of episodes will be legal advice, because simply we're going to be looking at the forms, and I'm going to be telling you what the stuff on the forms means, and then you can decide what you want to fill out, what you want to check, and ultimately it ends up being you as a self-represented litigant that has to appear in court and explain yourself. So it's really great to be back. Life has always takes its twists and turns. This is something I really enjoy doing, and it actually warms my heart when I meet with people and I talk to people, and even just random members in the community tell me that they watch the podcast, they love the content, they really enjoy what I do, and it's actually helped a lot of people having done this. And so a goal of mine is to just keep it going, release episodes as I can. Obviously, they're not on a consistent schedule, which I would love them to be, but nothing brings me more joy than just filming and being here to give the information and share the information and the knowledge that I have with the community here locally, obviously, whoever's watching it locally, and then the people that are consuming it online that I'll never meet, never see, never hear from. To me, that is what keeps me going and keeps this drive going. I've had a lot of time to try to think about what I think would be a proper next episode for Off the Cuff, and this felt right. I've been dealing with, I would say, a lot of self-represented individuals as of late, and it really struck me as, if I can help people help themselves, I'm also giving back to the community in that way. And that's part of, in my view, our job as counsel and as lawyers in the community is to help the community be better off with the use of lawyers. Even though you may not necessarily retain us, our job is also, as officers of the court, to advance justice as best we can. So that's the goal of these episodes, and I hope you guys enjoy them. So we'll take a little break, and we'll get right back into it with the court forms. Welcome back. So before I get into the court forms, I did also want to touch on something that we have been noticing at the firm a lot more, and that's the use of AI and ChatGPT for people responding to emails and letters and writing us letters. And it's becoming more and more problematic, given that, these chat GPT, AI, whatever program people are using, you can't fact check them. And the reality is that sometimes it gets it wrong. And so before I get into this whole thing about filling out the forms and being a self-represented litigant, I caution you, if you're listening to this, if you're watching, try not to use ChatGPT or AI carte blanche. And if you are using them, use them as tools to help inform you, or at least review what the program spits out before you send it off. There's nothing worse than copy pasting something that is completely incorrect, and or submitting case law to a judge that doesn't exist, which has happened recently here in Sudbury. And it's not really helpful to the court. It doesn't help instill confidence in your position if you are caught using the AI and the AI is wrong. It's just going to damage your reputation and your credibility before the judge that you're speaking to. So that's just my little tidbit of information. I know that it's on the rise. We're all excited about AI. Everyone's using it. Everyone's thinking that it's the best thing since sliced bread, but sometimes just using your own words is more effective than using a robot that spits out 20 paragraphs, which could have been said in one paragraph. So I just caution you on using that if you are listening. And so let's start and take a deep dive into these court forms. So the first thing we're going to look at here is the application. So this is the application general. This is what, if you are, in the Ontario Court of Justice. So you're gonna put your Ontario Court of Justice here. You're gonna put your address of your court. So you're gonna fill it out. And I do encourage you, if you're able to do that, is to type these forms rather than handwrite them. I know some people don't have access to a computer, and that's okay. And so in Sudbury, our court is at 159 Cedar Street. And so you're going to fill out your court location, and this could be anywhere. If it is an application, a simple thing here, your court file number. The court will assign that to you when you file your application, so you don't have to worry about that. If you are the one bringing the claim, you are, of course, the applicant. And if you're self-represented, then you don't have a lawyer, so you can leave that blank. Your respondent is the person you're bringing the claim against, so that could be your ex-partner. In certain cases, it could be another person. So the respondent is the person you're bringing the claim against. And then the children's lawyer, if you're just starting the claim, it's unlikely that a children's lawyer has been assigned. And so when you get to this part where the first court date is set, the court will fill that out for you in the Ontario court. So you don't have to worry about choosing a date. The court will assign a date to your file. So when you bring the application to the court, they will give you a first court appearance. And that first court appearance is where you will get to speak to the court for the first time about this case. And usually that date is given to you 30 days in advance, because when you serve this document on the other party, that person has 30 days to file a response in the court. And so a little tidbit, this application, when you are sending it out for service, has to be another person, not yourself. And so make sure you have a friend or a relative serve the application materials, and there are more than just this document, onto the other party. And then they'll have to swear what's called an affidavit of service. And the court staff can provide you with that form, and you can fill that out. So that's all you have to deal with in the first court date situation. The rest you don't have to worry about. The court will handle that for you. And then the next thing you have to turn your mind to is these questions, and they will apply to you sometimes. And so it's asking you to fill out a financial statement, Form 13 or a 13.1. And you just take a look at what each individual one is asking you. And a Form 13 is a financial statement that outlines your financial position. And we're going to go through that shortly. But the Form 13 is used in support cases only. And then the Form 13.1 is what we see in property cases. So in the Ontario Court of Justice, it is not likely you will use a Form 13.1, but you will be using a Form 13. So just keep in mind to that. Whereas the Form 13.1 often you'll see used in the Superior Court of Justice when you're claiming divorce and you're dealing with possession of a matrimonial home, you're dealing with property issues, or if your common law spouse is dealing with property issues between the two of you, again, though, that's going to be in the Superior Court of Justice. So for now, for the most part, you'll be in the Ontario Court of Justice using Form 13 if you are the person that is going to be asked to be paying child support or spousal support. The person that is requesting payment for child support, if you are simply requesting the table amount, which I'll go through very shortly, you don't actually have to file a Form 13. So as we go down, page 3 of the form gives you the demographic details of your case. And so here, this is where you're going to want to fill out as the applicant, your age, your birthday, your residence, being where you live, just the city, and of course the province, since when. And these two, if they don't apply, you simply will just put NA if there is no marriage and if you're in the Ontario Court of Justice. And then gender on the day before the marriage date. Of course, these are updated for today's purposes. And the respondent information, you're responsible to fill that out as well. Your relationship dates, again, married if applicable, separated when, started living together when, and you check the boxes as they're appropriate. Separation date is often one we see argument over or people don't understand. Separation means physical separation, or you can be separated in the same household. It just depends on the circumstances. We'll often ask our clients, when is the last time you slept in the same bed together, ate meals together, or presented yourselves as a couple out in the public together? And you start to ask those questions, and then you can really boil down to how long you've been separated and figure out what that date is. In most cases, in the Ontario Court of Justice, the separation date, that will trigger the child support payments. And so it becomes an important date when you're talking about, if somebody hasn't been paying child support and how long you go back to. and you would go back to the separation date for at least a claim for child support arrears. Here, of course, very self-explanatory. You fill out the children's names, and if there's more than one, you just add, if you're typing it, you can add as many fields as you want for as many kids as there are. You have to answer the question if there's been a court case about these parties or children before. Is there a written agreement? And what this is asking you is, have you guys entered into a mediation agreement or a separation agreement prior to commencing this? Notice of calculation or recalculation issued by an online child support service. So again, if this applies to you, you would hit yes or no. And again, answer the question below. And the last question before you get to the claims is if you've arbitrated this matter or any matter in the case, because that becomes important as well. This is the part where it starts to get confusing for people. The first part is fairly straightforward because you're just answering demographic information. But the claims here matter, and it matters what you choose. And so it matters also what legislation you are proceeding under. In the Ontario Court of Justice, you will never proceed under the Divorce Act. So here's just a common tip for people that are bringing these types of claims. Don't checkmark anything under the Divorce Act if you're in the Ontario Court of Justice. And it tells you only if you're in the Superior Court of Justice choose this. So what that means is any claim in the Ontario Court of Justice is dealt with under the Family Law Act or the Children's Law Reform Act. And so then here's where you're going to choose what claims you're going to make. So for example, support for me is another way of saying spousal support. And then support for the children. So if you're looking for child support table amount, which is you're not looking for anything more or less than what the child support guidelines say, you would choose that. Decision-making responsibility for the children, which is, are you looking for joint decision-making, sole decision-making? So you're telling the court that there's going to be an order requested. Parenting time. And then, are you in a situation where you are looking for a restraining or a non-harassment order? So you would choose that if that applies to you. Spousal support indexing. So if you're making a claim for spousal support, we typically will make a claim for indexing the spousal support. Declaration of parentage is if there's an issue of paternity, generally speaking, or if there's a question or not if one person is a parent. So you would choose that if that's an issue in your case. Guardianship over a child's property. Fairly self-explanatory if you're looking to be a child's guardian with respect to their property. Contact with child. This one here is what grandparents would choose. So if you're a grandparent watching this and you're looking for contact with your grandchild, because you're not looking for parenting time unless you're actually taking the child to live with you, in which case then you would be looking for decision-making parenting time. But if you're simply looking for contact, that is what you would choose. And then, again, wrongful removal or retention of children would be selected here for Claim 20 and 21. And then claims related to property in the Ontario Court of Justice, you're not going to be looking at these. If you find yourself in the Superior Court of Justice in a property case, then these ones would become more applicable. Then we move down to other claims, costs, annulment of marriage. Again, typically what we'll do is we'll seek a costs order, prejudgment interest, and then we usually say other and see below. Why we type see below here is because most self-represented individuals will miss this section, which is give details of the order that you want the court to make. So what we do here is, as lawyers, and when we're filling out these forms, is we will type in exactly what we want the court to make an order for. So an order for joint decision-making responsibility of the child James Smith, born January 1, 2024. And now you've told the court what you want, because you have to link the order to the claim. And that is one of the biggest pitfalls of self-represented individuals, is that the court doesn't actually know what you're asking for if you don't tell them. So here, if we continue, an order that the respondent of parenting time with the child James Smith, born January 2024, every second weekend from Friday at 3 p.m. to Sunday at 3 p.m. So now what you've done is you've told the court that you want the other party, that's the parenting time, that you want the court to make an order about. And if that is the case, then you're seeking an order for primary residence of the child James Smith, born January 1, with the applicant. So you've told the court you want joint decision making, you want the child to live with you, the applicant, and you've told the court about parenting time. And as a self-represented individual, if that's all you do, you're miles ahead of most people, because you have to advise the court what it is you want. Just like you go to a restaurant and order your meal, this is similar, where you're telling the court, hey, these are the orders I want you to make, court. And this is, again, where you would put an order that the respondent pay child support in accordance the child support guidelines for the child James Smith, born January 1, 2024. And you'll note that for the people that are listening, I'm orating as I type, so you have an idea of what I'm doing. It's so that there's consistency and the child is identified in the order. It's very important that you put the child's name and date of birth in any order made by the court, because that's how the children are identified. There could be two James Smiths, and there could be two James Smiths born January 1, 2024, but if this James Smith is the biological child of these two parties, you want to identify that. And it becomes also important if there's multiple children. And so even if you just do this and you've checkmarked these things above, you're in good shape with the court, at least. And also the lawyer responding to your application, if there is one, will know exactly what you are seeking, so that you don't have to have those discussions with counsel. The next part that we see skipped often, which you wouldn't assume that it would be, but it's this important fact supporting my claim. So if you're not using a part of the form, so important fact supporting my claim for divorce, this doesn't apply in the Ontario court. So what we do, we strike it out. We highlight it and strike it out. So it just deletes it. It doesn't delete it from the form, but it says, okay, I'm not relying on that part of the form. Then we'll move on. Important facts supporting my other claims. Here, this, again, is where people just don't put anything. But you have to tell the court exactly what it's asking you for. Set up all the facts that form the legal basis of your other claims. So this is where you would type things like the respondent, and you type it in first person. You type it as you, the person. And I have been in a relationship for 5 years. We separated on January 5th, 2025. the respondent and I have a child together, James Smith, born January 1, 2024. I am employed. I go to school, etc. So this is where you get to tell your story to the court. This is why we say you should type these forms, because this is where you're going to be able to advise the court why the court should make the orders. So if you're looking for child support, you'd say, I'm employed. The respondent is employed at Valet, and I believe they earn per year, but I have not been provided with proof any type of income. So in this statement, you're telling the court that where the respondent works, how much you think they earn, and there's missing disclosure. And of course, because you're just starting the claim, they haven't had a chance to provide you the disclosure. But if you've been separated for quite some time, the law obligates both parties to disclose their incomes to each other for the purposes of calculating child support. And so both parties have a positive obligation to do that. And that's right in the child support guidelines. And even with or without a court order, child support is easy to calculate because child support is very formulaic. And I would encourage anybody that is separated to look at your incomes and the residence of the children and use, if you have to, online calculators. It's in both parties' interest, the payor and the person receiving it, because that's going to support the children. But then the payor, if you are found to owe child support arrears later on, if you started paying them early on into the separation, you're not going to find yourself stuck with a large child support arrears order against you. So I would encourage parties to resolve child support issues early on in the case, at least even on what we call a without prejudice basis. Because on a without prejudice basis, what that means is you are not prejudicing your right to say that you shouldn't have been paying that support from separation because of X, Y, Z factors. And so it's better for you, the payor, to pay it early on and often without missing monthly payments, because especially on a without prejudice basis allows you to have that upper hand later on. If you are found to owe child support, you are not in rough shape facing a large child support order. The lawyer's certificate is obviously, again, if you're self-represented, you can, you would strike out this section here. So you would strike that out. And then, of course, it's asking you here in the applicant certificate, which is you, the applicant, you cite, date, and sign it. And so that's the general application. I've taken you through Form 8. So why don't we take a short break and we'll get right back into it after this.
This episode of Off the Cuff is brought to you in part by Weaver Simmons, Northern Ontario's largest full-service law firm.
Thank you for tuning into this episode, part 1, where we've gone through Form 8, the application. That was a lot of information for you to go through and digest. So I've broken this episode into 2 parts. Part 2 will feature Form 13 and Form 35.1 in the family court forms. And I'll go through with you how to fill those out, what the common pitfalls and mistakes are. Stay tuned for that. This is going to be a multiple part series of episodes relating to filling out family court forms, self-representing in family court, and the common mistakes and pitfalls that I see as counsel that self-represented litigants often make. I will just have my public service announcement out there that even if you are self-representing and you are communicating with counsel, don't always think that the lawyer on the other side is trying to pull a fast one over you. What we often do is try to get to the best resolution for both parties. At least that's our job as officers of the court and as counsel. We are there to assist both parties, and we have a duty to the self-represented individual to be fair and be be concerned with the state of the law and not misrepresent the state of the law to the self-represented person, and to make sure that we are in fact pursuing the interests of the children, if there are children, and looking out for what's in their best interests, while trying to craft a resolution that fits everybody's needs. So that's my little TED talk on just, if you are self-representing and you have counsel on the other side, rather than being combative and rather than trying to play this game of chess with the other side, work with the lawyer and be reasonable and rational. And oftentimes, especially if you have counsel on the other side who's looking to resolve this on an amicable basis, those are the opportunities you can take to craft resolutions outside of the court process and save everybody time and money. Because if you as a self-represented individual force an issue to trial and that lawyer has to run a trial, you might be facing significant cost consequences. So be careful with that. And especially nowadays in family court, especially in the Ontario court, we're seeing more and more cost awards being issued in the Ontario court against self-represented litigants because of the unreasonable positions that they're taking. So be cautious. Don't use AI. And if you have to use AI or think you do, please vet that AI and make sure you read the responses before you send them. So with that being said, thanks for tuning into part 1 of my TED Talk on how to do family law forms, and stay tuned very soon for part 2.